हेलो दोस्तों, स्वागत है आपका योर लॉर्डशिप के रिवाइज थ्रू एमसीक्यू सीरीज़ में। आज हम कंटिन्यू करने जा रहे हैं अपने सीपीसी के एमसीक्यूज़। यह होने वाला है आपका सीपीसी का तीसरा वीडियो लेक्चर, जिसमें हम डिस्कस करेंगे सीपीसी के इम्पॉर्टेंट एमसीक्यूज़ और पर्टिकुलरली दोज क्वेश्चंस विच हैव बीन प्रीवियसली आस्क्ड इन द कॉम्पिटिटिव एग्जाम्स। So we'll straight away start with the first question. Provisions with regard to res judicata are provided under which section of the CPC? Res judicata किस सेक्शन में दिया हुआ है? बहुत ही सिंपल क्वेश्चन है। आंसर इज सेक्शन 11. As we already know, other sections which were mentioned, we'll have a brief overview of that. Section 9 deals with the courts to try civil suits unless it is expressly or impliedly barred. Then section 12 deals with bar to further suit, section 100 deals with second appeal, and section 11 deals with the principle of res judicata. On which of the following maxim the doctrine of res judicata is based? A very simple question again, asked in various exams, West Bengal, Uttarakhand and so on. So the option is Q facit per alium facit per C, ex terpi causa non oritur actio, interest republicae ut sit finis litium, respondent superior. So you have to choose the correct answer. The correct answer would be the option number C, interest republicae ut sit finis litium, meaning thereby it is in the interest of the state that there should be an end to the litigation. Other maxims भी इसमें आपको याद रखने हैं, res judicata pro veritate occipitur or nemo debet bix xari pro uno et edem causa. So these maxims also deal with the principles of res judicata. Correct answer would be option C. It means that it is in the interest of the state that there should be an end to the litigation. Q facit alium facit per se आपको पता होगा, vicarious liability में use होता है, means he who acts through other acts himself. This relates to the law of agency and also the vicarious liability. Ex terpi causa non oritur actio means no action arises from a dishonorable cause. It relates to the illegality of the subject matter in contracts or torts. And then respondent superior also deals with the vicarious liability, means let the master be liable, let the master answer. It relates to vicarious liability. So we'll move to the next question. The next question is principle of res judicata applies to which of the following proceedings? In suits only, in execution proceedings only, in arbitration proceedings only, suit as well as execution proceedings. So the correct answer would be suits as well as the execution proceedings as well. This is provided in the explanation to section 11. The principle of res judicata under section 11 of the code of CPC applies to suit as well as the execution. Then res judicata means, and you have to choose the correct answer, staying the suit during pendency of the previous suit between the same parties involving similar issues. Not trying the suit if the suit involving similar issues between similar parties is decided. Bar to further suit or extending trial of the suit. So obviously, once you have read section 11, you will be easily able to answer that the correct option is option number B. Not trying the suit if the suit involving similar issues between the same parties is already been heard and decided. So that is why there is the rule of res judicata as incorporated under section 11 of the Code of Civil Procedure. Once a competent court has decided a matter in a former suit between the same parties and the same issue, the same matter cannot be reopened or tried again in the subsequent suit. Res judicata does not operate against which of the following parties? Between co-defendants, between co-plaintiffs, against a pro forma defendant, or none of the above. So co-plaintiff or co-defendant पे तो apply होता है res judicata, as you already know, but against the pro forma defendant वो defendant होता है जिसके against कोई relief claim नहीं किया गया है. He has no interest in the subject matter of the suit. Just for the reason of expediency or appropriateness, he has been implicated. So against a pro forma defendant, the principle of res judicata wouldn't apply, because against him no particular relief has been claimed, and he has particularly no interest that is involved in the suit. Once matter has been finally decided by a competent court, it cannot be reopened between the same parties. However, for res judicata to apply, the parties must have contested the issue. A pro forma defendant is a party who is formally included in a suit but doesn't contest the claim or participate actively. Since no issue is decided against them, res judicata will definitely not operate against a pro forma defendant. So that's the explanation. The rule of constructive res judicata is contained expressly in CPC, part of Supreme Court rules, a rule of equity, a product of judicial interpretation. So you have to choose the correct answer. जो explanation दिया हुआ है section 11 में, explanation 1 to explanation 8, उन explanation में आपको short form में पता होना चाहिए किस explanation में क्या चीज़ लिखी गई है, क्योंकि इस explanation पे ही direct question आ जाता है. It's contained expressly in the CPC. Option C would be the correct answer, and it is accordingly incorporated under explanation 4 of the section 11 to the CPC. Now we come to the next question: whether an issue heard and finally decided by a competent court of limited jurisdiction shall operate as a res judicata in a subsequent suit that the aforesaid court was not competent to try. तो कोर्ट ऑफ लिमिटेड जुरिस्डिक्शन है, उसने अगर कोई डिसीजन दिया है, सब्सिक्वेंटली ऐसा हो सकता है वो कोर्ट जो लिमिटेड जुरिस्डिक्शन की थी, दूसरा केस जब फाइल हुआ उसके पास वो अथॉरिटी नहीं थी कि वो डिसाइड ना कर पाए, उसके पास वो अथॉरिटी नहीं थी कि वो डिसाइड कर पाए उस केस को, तो क्या उस कोर्ट ऑफ लिमिटेड जुरिस्डिक्शन ने जो एडजुडिकेशन किया है वो रेस जुडिकेटा की तरह ऑपरेट करेगा, वहां पे ये रूल अप्लाई होगा कि नहीं, यही ये क्वेश्चन पूछना चाह रहा है. वेदर एन इश्यू हर्ड एंड फाइनली डिसाइडेड बाय अ कॉम्पिटेंट कोर्ट ऑफ लिमिटेड जुरिस्डिक्शन shall operate as res judicata in a subsequent suit that the aforesaid court was not competent to try. मतलब earlier the court was competent, it was a court of limited jurisdiction, but later on when the case is filed in a fresh suit, it might be possible that the court of limited jurisdiction is not competent to try the subsequent suit. So will res judicata apply in such case, in the case of court of limited jurisdiction? So ये आपका आंसर होगा yes, because this is accordingly provided under explanation number 8 of the section 11 to the CPC. An issue heard and finally decided by a court of limited jurisdiction competent to decide such issue shall operate as res judicata in a subsequent suit, notwithstanding that such court of limited jurisdiction was not competent to try such subsequent suit. So court of limited jurisdiction के केस में ये exception है. Even when that court of limited jurisdiction is not competent to try the subsequent suit, then too the principle of res judicata will be applicable in such cases, which has been heard and finally decided by a court of limited jurisdiction. ये explanation 8 में clearly mentioned है. So you must remember these explanations as well. Which of the following judgments of the Supreme Court deal with the applicability of res judicata in writ petition? बहुत ही simple case है. दरियाव वर्सेस स्टेट ऑफ यूपी would be the correct answer. Must be remembering. res judicata writ petition में एप्लीकेबल है ये केस जो है दरियाव वर्सेस स्टेट ऑफ यूपी में जो है डील हुआ था. Establish the applicability of the doctrine of res judicata to writ petitions under Article 32 and Article 226 of the Constitution of India. Which of the following judgment of the Supreme Court deals with the applicability of res judicata? This we have already done. The principle of constructive res judicata, explanation 4 में दिया हुआ है, ये भी याद रखना. The principle of constructive res judicata was explained by the Honorable Supreme Court in the case of State of UP versus Nawab Hussain would be the correct answer. Constructive res judicata पे जो केस है वो है State of UP versus Nawab Hussain. Daryav versus State of UP deals with the applicability of the principle of res judicata in writ petitions. So this you have already must have studied somewhere. State of UP versus Nawab Hussain. In this case, the court held that even though a particular ground was not taken in the first writ petition, the petitioner was barred from raising it in a second petition because he could have raised it earlier. So those issues which ought to have been raised, upon that the rule of constructive res judicata would apply, as provided under explanation 4 to the section 11 to the CPC. A decision in a suit may operate as res judicata against persons not expressly named as parties to the suit by virtue of which explanation. मतलब जो person expressly implicated नहीं है as a party to the suit, उसके ऊपर भी प्रिंसिपल ऑफ रेस जुडिकेटा अप्लाई हो सकता है. ये कौन सा सिनारियो है? ये बेसिकली रिप्रेजेंटेटिव सूट्स के केसेस होते हैं जहाँ पे कई पार्टीज, सब पार्टीज का नाम लिखना ज़रूरी नहीं है, लेकिन उनके ऊपर भी प्रिंसिपल ऑफ रेस जुडिकेटा अप्लाई होता है. दैट इज कवर्ड अंडर explanation 6 to section 11 to the CPC. So this would be the correct answer. Explanation 6 to the section 11 of the CPC deals with representative suit. Constructive res judicata, explanation 4. Court of limited jurisdiction, section explanation 8. So where persons litigate bona fide in respect of a public right or a private right claimed in common for themselves and others, all persons interested in such right shall, for the purposes of this section, be deemed to claim under the person so litigating. Therefore, if any decision is passed in such case, the res judicata will apply accordingly upon those parties, even though they have not been specifically named in the suit, because they are involved in a representative capacity in the suit. They are interested in the rights which have been claimed in common by several parties. So that is why there is no requirement to implicate those persons separately. Res judicata would still apply by virtue of explanation 6 to section 11 of the CPC. So that's all for today. Stay tuned for more videos on the previous MCQ, and do like, share and subscribe our channel. Thanks a lot.